everybody. Thank you so much for being here. Thank you for joining me. My name is Maureen. I am the founder and creator of BarMD. We're a full service bar prep company. So anything you need for the bar exam for the UBE, California, and other jurisdictions, we've got it, including stuff for multiple choice, the essays, the PTs. I've written 5 books on all of the things that you need for the bar exam. So anything you need, we've got it for sure. Just throwing it out there, we offer a free, totally free the bar exam, or even if you haven't, and you want to just come up with a strategy for passing the exam on your next try. So if you've not done one of these free strategy sessions, I highly encourage you to sign up. I put the link in the chat just now. Also, for those of you, I'm so happy that you're joining me live, so thank you for that. We're going to walk through these 25 released questions for the Cal Bar that are the multiple choice questions that are written for Kaplan, or written by Kaplan. So that's what we're going to do tonight. Tonight's workshop is going to be a little different than I normally do it. Usually I have a whole PowerPoint, all of that. This is really going to be me going and walking through all of the questions. I am going to walk through them. I'm going to mark it up on my iPad. So I know that you are taking the exam remotely. I am fully aware of this. The reason I'm doing it this way is because at the beginning, and right now we're at the beginning of bar prep, I want you to really focus on the learning of the multiple choice and the learning of the approach. And I think it's just easier to do that on paper. A really good resource for this is my multiple choice book, my MBE book. It has all of the black letter law. It has strategies and tips that you need. And then it has 410 of the MBE questions, which is still the best resource to prep for the upcoming exam. I know I've met with 100 some odd students over the last week, and I'm getting a ton of questions, actually no, like thousands, because of what I've done webinars. But I'm getting a lot of questions about what is a really good multiple choice resource. Are Adaptibar and UWorld still good? Absolutely, yes, they are. The California Bar cannot change the scope of the exam by law, by Business and Professions Code, without giving 2 years notice. So the questions are being written to be just like the MBE questions that you're used to or what you have seen. So absolutely, you can still use Adaptibar, UWorld, whatever it is that you prefer between the two. If anybody wants an Adaptibar discount code, there's 10% off. You can use BarMD10 and that'll get you 10% off. It's just, I put it in the chat. So, and if you click on the chat button, it'll put all the chat on the side. So if you miss a link, if I'm it popping up, you can click on the link in the chat still. It should still be there. All right, so we're going to dig right into it. I'm going to pull up the questions, and what I'm going to do is I'm going to be walking through these questions. I'm going to be showing you the level of depth of review of the answer choices and basically the process for doing it. And I'll also give you my observations about some minor differences with some of these questions that I have, that I have seen. I know every single released multiple choice question. I know them through and through. So I really do know, I can tell the differences between these questions and the real ones. There really aren't any. My opinion, now this is someone that knows every multiple choice question, and sometimes I still see some and I get tripped up a little bit, or I'm like, oh, that's really tricky. I thought that these were honestly, a little bit easier than a lot of the MBEs. So maybe that's, I hope it's music to your ears, especially for those of you that have a hard time in the multiple choice. I thought that it was. I did notice some points of law being tested here that I haven't seen be tested before. Still, it was testable, but it wasn't in released questions that I had seen before. So there may be some stuff that you're learning here, and that is entirely normal. There's not going to be enough of that for it to be super detrimental to you. That's normal. That we have that with the MBE too, for those of you that are wondering. Also, for those of you that are here, I've had 19 people input their answers. I would really love it if all of you put your answers in. If you haven't done all of them, that's okay. But put your answers in ahead so I can also have the data so that I can see where, what distractor did people miss. All right, so I'm going to put up on the screen the questions. And Sarah, yeah, that's fine. I think I'm saying your name right. All right, y'all should be able to see up on the screen now the questions, right? All right. I know it's a little bit tough to answer the questions while paying attention, so it's fine. I'm going to read through them, and then I'll give you guys a minute to input your answer before I give you the answer. So just as a heads up on that. This one starts. So first, we always read the call of the question first to get just acclimated. We want to identify what the narrow issue is within the fact pattern. So we always want to be starting with the call of the question. So first, it says here, was the president's initial action of deploying U.S. forces constitutional? So was that constitutional? So I know we're dealing in common law here, and all of these questions you probably noticed they're all just grouped by subject. So, they're not all mixed up like we would expect on the real exam. So it says here, a U.S. naval base located on the coast of state A, so it's a U.S. naval base. I know that the president is commander-in-chief, suffered a sudden attack launched by a foreign nation that resulted in several casualties and significant damage to the ships docked at the base. The base was one of the largest in the country, I'm going to just underline as I go, and served as an artery for all inland military operations. So this is squarely within the president's power as commander-in-chief. Within an hour of the attack and without prior congressional authorization, right? What do you need congressional authorization for? Right? You need it to declare war, right? Yeah, you need it to declare war, but a president can take military action on their own. So the president responded by increasing air defenses and naval presence at all U.S. military bases and deploying forces domestically to retaliate and ward off further attacks. So squarely within the president's power. So was the president's initial action of deploying U.S. forces constitutional? So notice here, it's saying just the initial action of deploying U.S. forces, which I think is kind of a funny thing. I think they could use this question and do variations. They could ask about, let's see, increasing air defenses and naval presence, deploying forces domestically to retaliate and ward off further attacks. I think they could ask, multiple different things here. So was the president's initial action of deploying U.S. forces constitutional? So put your answer in if you haven't already, please. The poll, into the poll, the webinar poll. So there's a lot of debate here. A lot of C, a lot of D is what I'm seeing here. A lot of C and a lot of D. So, but we're going to go through all four. We always look at all four answer options. And this is something that is really important that I want you to do. If there is a single answer explanation that you can't explain, then that means that you need to do a little bit deeper digging onto that answer option. So A, no, because Congress alone may determine any military action. This is incorrect. This misstates the law because it's not Congress alone. The problem here is that it says Congress alone may determine any military action. There's also the word any in it. I generally don't like that word in multiple choice answers. It's just generally not a good one to pick. So it's usually overbroad, kind of like an absolute. B, no, because Congress must authorize any military action by the president within 1 hour of the action. I don't like this either because it says must authorize any military action. That's overbroad. And it's too restrictive too, because it says within 1 hour. There's no such 1 hour requirement. So this again misstates the law. C, yes, because the president has the power to repel sudden attacks. So yeah, the president does have power to repel sudden attacks. I don't love this answer. That's kind of weird phrasing to me. And I bet a lot of you were between C and D. So I'm betting a lot of you were between C and D. So let's look at D. And D says yes, because the president has the plenary power granted as commander-in-chief to protect U.S. soil. D is an overbroad statement. That is not a true statement of the law. The president has power as commander-in-chief, but plenary is an overbroad statement. So it's not plenary. So it's literally just this one word makes it incorrect. So C is correct. Now, I don't love the language in C. I haven't seen that language before, but it's true. And I'm like, all right, well, the president is commander-in-chief. President does have the power to repel sudden attacks, and they can take certain actions. It doesn't say that they can do anything, though. So C has enough restraint in it. So C is the correct answer. That's what the majority of you picked. 55% of you picked C, which is good. D, I get why that is an attractive answer. It has kind of more constitutional language in it than C does. And I see that, but don't be tripped up by that. Yeah, plenary is like full absolute power, right? Like basically, like there's not a lot of powers that are like totally absolute in plenary other than the pardon power for federal offenses. That's essentially that's the one I think of where it's just such a strong one. All right, is the Supreme Court likely to hear the case is question 2. So to me, it's getting at, okay, this is getting at like your preliminary issue, your standing, ripeness, mootness, 11th Amendment based on this. So it says here, State A acted a new law to discourage price gouging during environmental catastrophes. The law sought to prevent the inflation of gasoline and hotel prices frequently seen during the aftermath of a hurricane or forest fire. A gas station owner in State A believed that the law violated the Commerce Clause as well as various individual rights guaranteed under the U.S. Constitution. The gas station owner has filed a suit directly with the U.S. Supreme Court challenging the constitutionality of the law. So, can they do that? The poll, I can't resend the poll. Sorry, Lee. I know people are, if somebody wants to write in the chat how you re-access the poll, go ahead and put it in there. Yeah, I can't. So here, is the Supreme Court likely to hear the case? So let's look at it. A, no, because the suit did not take the proper route to the Supreme Court. Yeah, this looks pretty good because they filed directly with the U.S. Supreme Court. That's an original jurisdiction. This is not a case where the Supreme Court has original jurisdiction. The Supreme Court has very limited original jurisdiction that cannot be expanded. And so we can't expand it to include this. Congress can't even do that. And then this is not one that falls within the categories of where there is original jurisdiction, such as like a conflict between states, etc. So A looks like a good answer here. B, no, because the suit presents a non-justiciable political question. It's not a political question because it's challenging a law. Challenging a law is not a political question. So this kind of mischaracterizes the facts because it's not a political question because they're directly challenging a law. C, yes, because the suit implicates individual rights and therefore falls under the Supreme Court's original jurisdiction. This misstates the law because individual rights don't even fall under the original jurisdiction. So you should be able to look at the answers and write out, why is this wrong every single time? And as you practice and get used to this, if you're looking at this and you're thinking, well, I know it's wrong, but I can't explain why, you need to get in deeper and you need to be able to understand it. You need to say like, it's this word in here, or this mischaracterizes the facts because this isn't a political question. And why is it not a political question? And it's because it's challenging a law that's been passed. That's not political. So, and individual rights don't have original jurisdiction. And then, so something that somebody said in the comments. So a lot of people here, let's see, predominantly picked A. A lot of people picked D though. 28% of people picked D. 10% of people picked B. And D says yes, because a suit implicates the Commerce Clause. Just implicating the Commerce Clause doesn't do it. In order for the court to hear a claim, it has to be stated in the complaint. And here we have the gas station owner that has filed a suit, not the state. So it's a gas station owner versus, whoever the AG is probably. So that's what's wrong with D is D doesn't, just because a suit implicates the Commerce Clause doesn't mean that it involves the state, which is what somebody says. And just because it implicates the Commerce Clause, it doesn't mean that it falls under the original jurisdiction. So this is really getting at, do you know what kind of does and doesn't fall under the original jurisdiction of the Supreme Court? And can you tell that this doesn't? And what route would this need to take? This gas station owner could absolutely file this suit, but they've got to file it in district court. So it's a federal question, file it in district court. And a lot of people are asking me questions. There is not more sample questions yet. The best questions are the ones in Adaptibar, UWorld, everything else. I don't know if Adaptibar is going to have added these questions. I have no idea. All right, number 3 here. So here, did the football player's suspension violate his right to free speech? So here we're dealing with speech. So still in con law. A high school football player painted smoke pot on a school-issued jersey. The football player wore the jersey during a practice that took place at the school during his lunch hour. The school principal attended the practice and had the football player removed from the practice, which is okay. One thing in this question that's slightly problematic is that they don't say that it's a public high school or a state high school, so I'm assuming that it is. So the principal alerted the football player that he was suspended because his message promoted illegal drug use, violated the school's policy against drug use, and undermined the school's authority. The football player sued the school district, claiming that his suspension violated his right to free speech under the First Amendment. So let's look at these. Did the football player suspension violate his right to free speech? So A, no, because the football player's jersey caused a substantial and material disruption to the school's educational environment. A is incorrect. That may be true. Even if that's true, that is not the basis for answering whether it violated his right to free speech. So yeah, so disruptive behavior can be regulated. Yeah, it absolutely can be regulated. Yeah, but that's not the reason that that it doesn't violate his rights here. So, and it also mischaracterizes the facts. It doesn't actually state in the facts. Oh yeah, so yeah, somebody's saying tinker. Yeah, that's right. it doesn't actually state in the facts that it did cause a substantial material disruption. So we don't actually know that that's true. So I'm going to say A here mischaracterizes the facts, or it goes beyond the facts. B, no, because the school has the authority to regulate student speech that promotes illegal drug use. That's true, right? The school does have the authority to regulate student speech that promotes illegal drug use. This does do that because it says smoke pot. Granted, federally, we have to assume this is federal still, and federally it's still not legal to smoke pot, generally. So B looks good. C, yes, because the First Amendment guarantees freedom of speech, even among high school students. C overstates the law. It's not absolute. So First Amendment doesn't guarantee all freedom of speech. Doesn't guarantee. And this is a type that can be regulated. And I think most of you got this right. 70% got B. Then C, there was a second big answer here. So C just overstates the law. And you have to see why it's that, because it doesn't always guarantee freedom of speech. It does guarantee freedom of speech even among high school students, but there's limits to it. And this is one of those limits. D, yes, because the football practice was a recreational activity that did not take place in a classroom. That's irrelevant. So free speech, when it's a school sanctioned activity, the school can still regulate the speech. So this sort of misstates the law. So school, yeah, public school. This is a public school, presumably. And yeah, you can regulate speech that promotes drug use. Yeah, that's exactly what's happening in this question. All right. Now let's look at question 4. So do you guys see, like when I look at this, I'm going through all 4 answers each time. And if you got it wrong, you have to really know, okay, well, what's wrong with it? What word in this? So I'm trying to point out the words that are the signals to me in the incorrect answer choices. And that's what I want you to be doing. Do you guys see that? Tell me in the chat. When you missed it? Okay. Because that's the reason I really want to go through every single one of these, is I want to point out what is wrong with the incorrect answer choices. And if you cannot explain it like I'm doing, then you need to dig deeper. And it's not always just that you didn't know the law. And yeah, I agree. Somebody said that the words that are being used in some of these answer choices are a little bit different. I thought in the very first one saying the president has a power to repel sudden attacks. I'm like, I haven't seen that language. I haven't seen that language before. So that threw me off. And stuff like that is what I'm seeing. But I can still eliminate all the other 3 in the same way that I've been doing for years with the multiple choice questions with the MBE. All right. Start with the call to question. Would the dealer prevail in a lawsuit? Question 4. Some split answers here. So a car dealer sent in an order form to a tire manufacturer for 200 premium tires. This is UCC. You always want to answer that first. At $50 per tire with delivery at the dealer's location in 30 days. So this is an offer. It's UCC. Upon checking its inventory the next day, the manufacturer realized that it had only 180 premium tires in stock. The manufacturer then shipped 180 premium tires to the dealer 20 days later, which is within the terms of the offer, along with a notice indicating it was shipping the tires for accommodation only. So this is a counter offer. And I don't always love when they say a counter offer for this, but it is a way to say that this is a counter offer. When you ship an accommodation, it's a counter offer. If you didn't ship the accommodation with it, it would be an acceptance and an immediate breach. But because they shipped the accommodation with it, it actually is a counter offer. The dealer received the shipment and placed the tires in his warehouse. So they accepted the counter offer. Contracts questions, you've got to you have to keep track of the questions as you go. And also just throwing a little plug here I have a course for MBE. It's called MBE Minutia, where we walk you through questions and there's tips and all sorts of stuffs that I do for all of the subjects. So you should check that out. And I'm going to have a bit of a promo at the end of this session too, that you can use for basically anything other than tutoring. So just as a heads up. So dealer received the shipment, placed the tires in its warehouse. The dealer then contacted the manufacturer, stated that although the tires met the terms of the order, the dealer intended to sue the manufacturer for breach and failing to ship 200. Can't do that because it was an accommodation. So will the dealer prevail in a lawsuit? No, they absolutely won't. No, because the manufacturer made a counter offer for 180 premium tires by shipping the tires for accommodation only. That looks like it's the correct answer here. So I think that looks good, but I'm still going to go through everything else. B, no, because the 30-day time for delivery has not yet passed. That's not what we're dealing with here. I know that could be a correct answer, but this was a counter offer saying here's 180. So we don't even have to get to the 30 days. It doesn't, that's when you have like an opportunity for it to cure, right? So if you had shipped it, if there was an acceptance of the initial offer, then you would have the opportunity to cure, but we're not dealing with a cure situation here. We're dealing with a counter offer and an acceptance of the counter. So like here, I'm just going to say not dealing with cure. This is a counter offer. C, yes, because a dealer may reject a non-conforming tender. This isn't a non-conforming tender because it was an accommodation. So this misstates, I'm going to say mischaracterizes the facts because it's not non-conforming. It was a counteroffer. And then D, yes, because a shipment of the 180 premium tires constituted an acceptance of the offer and a breach of the contract. Again, this mischaracterizes the facts because this was an accommodation. So I'm just going to say same as. So the correct answer for 4 is A. A lot of people pick D, or pick B rather, but we're not dealing with a cure situation. So I thought this one was a little bit trickier compared to some of the others, just to compare to the con law ones that we've seen so far. Notably, the con law ones they gave us didn't deal with like all the equal protection, substantive due process stuff that can be tricky, I think, for a lot of people. All right, Q5. Who bears the risk of loss for the destruction of the canteen? So this is just sort of like, this is, as long as you know what the rule is for like FOB, state B, and you know the terms here, you're going to be okay. But risk of loss, we know these are just rules that are kind of detailed, but you just really have to know. And typically, typically the buyer has the risk of loss once it gets to the shipper. So on January 1, a department store emailed a purchase order to a manufacturer of steel drinking canteens for the purchase of 1,000 steel drinking canteens at a price of $35 per canteen. So this is an offer. Manufacturer was to have the canteens to the store, which was located in State A, by January 5th. The manufacturer, located in State B, responded immediately by email accepting the offer, stating it would ship the 1,000 canteens FOB State B. So FOB State B. So the risk of loss transfers once we get them to the shipper in State B. The next day, the manufacturer indicated to the store that it had delivered the canteens to a shipper. While in transit, so after the risk transferred, the shipper's truck was involved in an accident which destroyed all of the canteens. So who bears the risk of loss? It's going to be on the store that made the purchase. So the store, because the term FOB indicates a shipment contract. So here with A, generally speaking, the location FOB, it's just FOB just means free on board. And it indicates, where we're shipping from or where the risk of loss transfers. So here's State B. So FOB doesn't just implicate a shipment contract. So I'm just going to say this misstates the law. B, the store, because the manufacturer delivered the goods to the shipper in State B. That is what's happening here. And I think most of you picked B. Yeah. So that's the risk of loss. Once they got it to the shipper in State B, risk of loss transferred. C, the manufacturer, because it entered into a destination contract. So you need to know what a destination contract is. So a destination contract is a seller is responsible for delivering the goods to a specified destination and bears the risk of loss until delivery is made to that location. So FOB State B means that it's a shipment contract, so not a destination contract. So this mischaracterizes the facts. And D, the manufacturer, because it chose the shipper, this is irrelevant. So choosing the shipper doesn't designate the risk of loss. So B is our correct answer. This is a shipment contract. It is, but the problem with A, which I think a lot of people, I'm getting some questions in the chat. FOB doesn't indicate the term FOB does not always indicate a shipment contract. It can also indicate a destination contract. Here it does, but this term doesn't always mean that. And this is too broad of a statement because it says because the term, not the term here, or not because the way the contract is written is a shipment contract. I think this could be a little bit more clearly written, but it's there. All right, let's look at 6. So it says, how should the court rule on the employee's motion? So an employee signed an employment contract with the manufacturer. The contract included a non-compete clause. The contract also included a liquidated damage clause, specifying that if the employee were to breach the non-compete clause, the employee would pay $50,000 in liquidated damages. It's probably way too high. Liquidated damages they can't be just like a penalty. They have to actually reflect the actual damages. Stating that the amount of liquidated damages was reasonable, doesn't matter that you say that, doesn't make it so. And 3, declaring that liquidated damages did not constitute a penalty. Again, just saying it doesn't make it so. Sometime later, the employee voluntarily terminated his employment with the manufacturer and took a job with a competitor. the manufacturer then brought a breach of contract action against the employee, seeking to enforce the $50,000 liquidated damages clause. At a bench trial, to support the liquidated damages amount, the manufacturer did not offer any evidence of the actual damages, which is what you have to do. Instead, the manufacturer offered evidence of the cost of subsequent litigation that doesn't determine your damages, involving enforcement of an employment contract with a non-compete clause with another employee and the cost of hiring and training that employee's replacement. At the close of the manufacturer's case, the employee moved for JMOL, claiming that the liquidated damages clause was unenforceable. So one thing to point out here is you need to know the standard for a JMOL as well here. So we see CIF Pro all over the bar exam, which is why I always start people off with civil procedure when they start to study for the bar, because you're going to see it more than just here. So how should the court rule on the employee's motion? A, deny the motion because the contract declares that liquidated damages did not constitute a penalty. This is insufficient to render the clause enforceable. It also doesn't address the JMOL. B, deny the motion because the amount of liquidated damages was reasonable. Nothing is shown that it's reasonable. This mischaracterizes the facts because nothing was demonstrated. C, grant the motion because liquidated damages were limited to the breach of the non-compete clause. That's irrelevant. The liquidated damages clause here is unenforceable because it's not an accurate reflection of the damages. And it's not a basis to actually grant the motion as well. So, I'm sorry, that's not the basis to grant the motion. It's not getting at the standard. And then D, grant the motion because the amount of liquidated damages was not reasonable in relation to the actual damages from the breach of the non-compete clause. That's our correct answer. This gets at the law, it gets at what's issue here, because it tells us it's addressing the fact that the $50,000 is not related or reasonable to the actual damages from the breach. This particular question, I think, is one that is not the best written. I think it gets a little bit muddy in it. I know that, just as a heads up too, like I know these are released and then the bar is getting feedback and they're fixing stuff. The bar hasn't asked me, they won't talk to me because I have a commercial interest in the bar exam, but I know so many people that are good that are working on this stuff and know these issues. So, and if you want some specific details on all the rules, you have answer explanations for all of these too. But generally speaking, the rule here is it's just a test for when are liquidated damages enforceable. When is a liquidated damages clause enforceable? Oh, that's great, Jennifer. I didn't know that. Will you forward that to me, Jennifer? Cool, thanks. Number seven. A minor worked at a fast food restaurant. Oh, actually, it starts with call the question. How should the court rule on the fast food restaurant's motion to compel arbitration? Usually there's an arbitration clause in a contract, so we're probably still dealing with contracts. So, but here it's a minor, and minors can disaffirm a contract, or they can they can choose if they want to affirm it. So a minor worked at a fast food restaurant. While on the job, the minor was injured while using a vegetable slicing machine. As a result of the injury, the minor quit her job. The minor then brought suit against a fast food restaurant alleging negligence. At the time that the minor began her employment, she had signed a contract agreeing that any claims against the fast food restaurant, including for negligence, would be resolved in binding arbitration. Prior to trial, the fast food restaurant moved to compel arbitration. The minor filed an opposition to the motion to compel, in which she asserted that the agreement to arbitrate was void. And so, yeah, the minor here can disaffirm that contract because they were a minor when they entered into it. So, A, deny the motion because the minor effectively disaffirmed the agreement to compel arbitration. That's correct. The minor did effectively disaffirm, and they have the power to do that. B, deny the motion because the minor lacked capacity to enter into the agreement. Is that correct? Did the minor lack capacity? They didn't lack capacity. There was infancy. So this misstates the issue. It's infancy is what it's called, not capacity, just the age. Yeah. But sometimes people are like, well, is capacity like the same thing as age? Right? But because it can often be tied to it, but it's not the case. C, grant the motion because the minor did not expressly disaffirm the agreement to arbitrate before filing suit. You don't have to do that, so this overstates the law. And D, grant the motion because the minor had capacity to agree to binding arbitration. Even though the minor had capacity, they still had the right to disaffirm. So this is true, but still had power to disaffirm, and they did. Jennifer, I just saw your Q&A question. Can you email me where you saw that? Yeah, that's true. So yeah, even if a minor lacks capacity, they can still disaffirm the contract, but they can enter into a contract. Yeah, exactly. Minor, oh, even if, yeah. All right, now moving on to criminal law. Which of the following is the most appropriate crime for which the co-felon may be convicted? As soon as I see a co-felon, I'm thinking of like accomplice liability, conspiratorial liability. So defendant and a co-felon decided to go to a local drug dealer's home in order to buy drugs. On the way, brilliant guys, or gals, I don't know. The defendant and the co-felon decided to rob the drug dealer of any money he had on hand from other drug sales instead of buying drugs. Unbeknownst to the co-felon, doesn't matter, the defendant had concealed a loaded revolver that he planned to use to threaten the drug dealer. Upon arriving, the defendant and the co-felon approached the drug dealer and asked to buy drugs. As the drug dealer reached into his pocket, the defendant suddenly shot and killed him. The defendant and the co-felon then fled without taking any of the drug dealer's money. Doesn't matter. Shortly after, the two were arrested. So, what kind of a crime did they commit initially? What did they set out to commit? Robbery. Robbery. So, when you commit robbery, you can be convicted of felony murder. And here it was felony murder. So, the answer is B. So, it's not depraved heart murder because, generally speaking, because this is just felony murder. So, the co-felon can't be convicted of depraved heart murder because he didn't consciously disregard a substantial and unjustifiable risk to human life. So, co-felon doesn't meet requirement. Felony murder, yes. Intent to inflict serious bodily injury murder, not true. Co-felon didn't. Co-felon just intended to do the robbery. So I'm going to say mischaracterizes the facts. So which is the same as A, mischaracterizes facts. And then intent to kill murder, again, mischaracterizes the facts. He had no intent to kill. He had no intent to cause any harm. He just wanted to rob the dude, right? So the co-felon can't be convicted of ITK either. Again, this mischaracterizes the facts. And what did most people do here? Yeah, pretty much everybody picked B here. Question 9. May the police officer be convicted of common law assault? All right. So a police officer was angry with a neighbor for continuously playing loud music at all hours of the day. I'd be mad too. I feel like I'm getting like crotchety old person, but you know. One evening, the police officer decided to put an end to the noise. Doesn't sound great. Police officer just knocked on the neighbor's door, and when the neighbor opened it, the police officer drew his service revolver, a bit aggressive, pointed it at the neighbor, saying, "I've had enough of this noise." The police officer then pulled the trigger, but the gun misfired. The neighbor responded by laughing and closing the door. So this is, can he be convicted of common law assault, right? Intending to cause apprehension, right? He intended to commit a battery here. So may he be convicted? The gun misfired, that's irrelevant because he still didn't have the intent because he intended to commit the battery and it transfers to assault. B, no, because the neighbor was not put in fear. Doesn't matter. There was still, he intended to commit the battery, so that's all right. C, yes, because the police officer intended to commit a battery. There's our answer, right, that we were predicting. And D, yes, because the police officer was reckless in pointing the revolver at the neighbor. This isn't required. So I'm going to say this is not required. And I'm going to say again, intent to commit battery. So every single time, we're going through all 4 answer choices. And it's going to be even more important. I think, you always want to try to predict the answer. You always want to try to predict the answer once, before you look at them, which I'm, generally doing. But then I want to look for the answer that I'm looking for so that I'm not sidetracked. And then I still want to just double check and strike the others, particularly as you practice. And anytime you see a question and you're like really tempted by 2, you really need to dig in deeply. Sorry, I just double checking one thing. Number 10. So hopefully it might be 2 hours this evening. I thought we were going to go till all the way to 9. We might be done a little bit before that. And make sure you stay for the whole thing because I've got a deal at the end. Should the court grant, and you just want to go through this analysis. Should the court grant the motion to suppress the man's statement about the gun? So motion to suppress statement, I'm thinking 5th Amendment, 6th Amendment. So police officers arrested a man they believed recently committed an armed robbery. This question, how many of you guys recognize this question? Anybody recognize this, seeing it before? Yeah, almost everybody. This question is almost identical to a real question. So whoever wrote this, red flags went off on this one for me. So police officers arrested a man they believed recently committed an armed robbery. The man was placed in the back seat of the police car and given his Miranda warnings. So given Miranda warnings. So if we're dealing 5th Amendment here so far, because he has not yet been charged. The man said he wished to have a lawyer present during any police questioning. So he has unequivocally invoked Miranda. They cannot question. They cannot question. So is he in custody? Yeah, he's in the back of a police car. Is there an interrogation? So as the officers drove the man to the police station, they engaged in conversation between themselves in the front seat. One of the officers mentioned that there was serious concern because a weapon used in the robbery had not been recovered. He further stated that if the weapon was hidden near the scene of the robbery, then it was in the vicinity of a local nursery school. The other officer voiced a concern that a young child might discover the weapon and accidentally fire it. After hearing the officer's conversation, the man stated, so before we get to what the man said, all of this stuff back and forth between the officers, that's designed to elicit an incriminating response. It's designed to elicit an incriminating response. So after hearing the officer's conversation, the man stated that he had hidden the gun near the nursery school beneath some bushes. Prior to the man's trial for armed robbery, the man's lawyer made a motion to suppress the man's statement about the gun. This was an unlawful questioning. This is an unlawful questioning. A lot of people picking different answers here. A lot of people typed in the chat C, or a few people did. A lot of people saying B, there's some A's, but let's go through this. No, because the man impliedly waived his Miranda rights by speaking to the police. That's not the case here. They question. He had already invoked his right to counsel. They had to abide by that. Oh, hey, Susie. B, no, because the man voluntarily admitted where he had hidden the gun. He didn't do it voluntarily. He invoked his right to counsel, and then they're basically questioning him by making all of these statements. So that amounts to a questioning. It was likely to elicit an incriminating response. C, yes, because the conversation between police officers occurred while the man was in custody. That is insufficient. It's not just that it occurred while he was in custody, it's that the conversation amounted to an interrogation. So I'm just going to make notes. He invoked. This is incorrect because this kind of mischaracterizes the facts. He invoked, I'm just going to say RTC, right to counsel. This is insufficient. And it's also like the imprecise, it's not the right issue. So issue is incorrect. We're not talking about custody. Custody is not at issue. This must be based on a case. Yeah, Rhode Island, Vienna. Oh yeah, somebody said Rhode Island in the chat. But the questioning is the conversation that the officers are having. So this, officers are having this conversation because they know that it's likely to get this person to say something. So that's, it doesn't matter that the police officers are engaging in the conversation between themselves. They're doing it because they know that even criminals probably don't want little kids to get hurt. Right. So that is likely a reasonable person is likely to elicit an incriminating response if you say all of this stuff. So this comes from a case. Yeah, it doesn't matter that the conversation was between the officers. All right. How should the court rule on the objection? Yeah, how should the court rule on the objection? A salesman had long been employed at a department store. The store recently hired a new manager. The manager was openly hostile to the salesman. The manager frequently insulted the salesman, often ignored him, and refused to speak directly to him unless another employee was present. The salesman had an exemplary employment record with no disciplinary action ever taken against him in the years that he had worked at the store. The manager eventually terminated the salesman, giving no reason for doing so. The salesman then brought an employment discrimination claim in federal court. So employment discrimination claim, we're in federal court against the manager. At the trial, the salesman offered testimony from a store employee who would state that the salesman was known as an honest, dedicated, and exemplary employee. The salesman is bolstering. He's offering evidence of his own good character. He hasn't testified, so we can't have anything about him being honest and him being a good employee when he worked at the store. That is not, so this is a character question, and it's, can you introduce his character? It's employment discrimination, so is character at issue? No, it's not at issue. So you have to know when you can introduce character, and it's limited. So A, overruled because the salesman may offer evidence of his good character, and I'm going to say no, because it's a civil case and character is not at issue. B, overruled because the testimony is evidence that there was no cause to terminate the salesman. The testimony is evidence that there was no cause to terminate, but it's still improper character. I'm going to say this is true, but still improper character. C, sustained because character evidence is inadmissible in civil cases. This overstates the law. It's not always inadmissible. It's admissible in certain circumstances. So D is our correct answer. Sustained because this type of testimony is inadmissible in an employment discrimination case. That's correct. That's correct. So 11 is D, which there was answers kind of all over the place here. But yeah, D is our correct answer. Love the ego stroking here. Thank you in the chat. I appreciate that. Just keep me going. I'm just like, I feel for you guys going into this exam with these unknowns. So that's why I wanted to do this for free, because I think it's important. And I like, my goal with this, I own I own the company, but my goal is to make access to becoming an attorney more affordable and accessible. In 11, why was the answer not A? Because you can't offer evidence of good character here, because character is not at issue in the case, and it's evidence of his bad character hadn't been introduced. So essentially, because it's character is really limited in a civil case. All right, how should the court rule on the objection? So a motorcyclist was injured when a driver's car collided with a motorcycle. Shortly after the collision, a police officer arrived on the scene. The police officer observed the damage to both vehicles and also interviewed both the motorcyclist and the driver. Several weeks later, the motorcyclist filed suit against the driver in federal court. During discovery, the police officer gave testimony at a deposition describing the accident scene, so this is testimony, and her interviews with the motorcyclist and the driver. The driver's attorney had a full opportunity to question the police officer at the deposition, so that's telling us that this testimony has been fully developed. Prior to trial, the police officer suffered serious injuries on the job. When the police officer was called at trial as a witness by the motorcyclist, the police officer testified that the injuries she had received rendered her unable to recall any of the details of her investigation of the collision. This makes her unavailable as a witness, her complete lack of memory. The motorcyclist then offered into evidence the deposition testimony of the police officer, and the driver objected. How should the court rule? A, the court should overrule the objection because the police officer has no memory of her investigation. What do we think about that? That's pretty good, right? She's unavailable. So when you're unavailable, then we can use former testimony so long as the testimony was sufficiently developed. So this looks pretty good, but let's look at the others. The court should overrule the objection because the police officer's testimony at the deposition was given under oath. That's true, but it's insufficient. So it's insufficient. It also has to be, they also have to be unavailable. Yeah, and there has to be a full opportunity to develop the testimony. So the same opportunity and something else. But so C, the court should sustain the objection, so wrong result, because the police officer is available as a witness. They're not available. So this mischaracterizes the facts because no memory means not available. D, the court should sustain the objection because the police officer's testimony of the deposition is hearsay. It is hearsay, but there's a valid hearsay exception. But former testimony exception applies. How should the court rule on the application to compel the social worker to answer the questions? Social worker here, this one's a little trickier, I think. A police officer was on patrol when he saw the defendant threatening a victim with a knife. The police officer ordered the defendant to drop the knife, but the defendant showed no response. When the defendant took a step toward the victim while brandishing the knife, the police officer shot the defendant. The defendant then brought an action in federal court against the police officer. After the shooting and before the trial, the police officer sought counseling from a licensed clinical social worker due to symptoms of depression that he was experiencing related to the shooting. What protection is there for social workers? Social workers, a therapist and their clients. A lot of people are saying none. All right, so let's keep going. At trial, the defendant called the social worker as a witness and asked about conversations the social worker had with the police officer during the counseling sessions. There is a psychotherapist patient privilege. Even though we don't have doctor patient privilege in federal court, we do have therapist patient privilege. I don't know why. I think it's kind of silly. Every state does have doctor patient, but we don't have it federally, and we're in federal court. So, and we're not sitting in diversity. If they said that we were sitting in diversity, then maybe. So I think this question could be improved a little bit, but nonetheless. The social worker refused to answer those questions. The defendant made an application to compel the social worker to answer. So how should the court rule? They should deny it because they're protected by psychotherapist patient privilege, and they are. So you do need to know that like a social worker is a therapist. So A looks like our good answer here. B, the court should deny the application because the conversations were presumably intended to remain confidential. That is insufficient. That is insufficient to render it inadmissible. Sorry, my dog wants to come encourage you all. Yeah, social worker's therapist. Yeah, LCSW. All right, so this is insufficient to compel or deny. All right, C, the court should grant the application because no privilege exists between a licensed clinical social worker and a patient. This misstates the law. So I thought this is tricky because it said social worker and they're using that term, intentionally. They're not just saying psychotherapist or saying a social worker. So you need to sort of have that knowledge. D, the court should grant the application because the conversations are relevant to the police officer's state of mind. So this, it is, it's true, but it forgets about the privilege. So this happens a lot where it's actually a true statement. It's actually a true statement, and we've seen this a few times, but it's not what's actually getting at the issue here. It forgets about something. So this forgets about the privilege. And like George said, yeah, and this is true. He said that's why these questions are so difficult because they test rules that aren't in textbooks or law school. That happens in the MBE too. So I don't think these are more difficult than the MBE questions. They've had this there too. But yeah, psychotherapist. So there's all sorts of different ways you can be a therapist. You can be an LCSW, you can be a PsyD, you can be a PhD, all of that stuff. All right, how should the court rule on the objection? So we're dealing with evidence again. A security guard at a retail business hatched a scheme in which he would disable a security camera and then leave the door to the business office unlocked so that an accomplice could enter, force open a safe, and steal its contents. The next day, the security guard ended his shift and left the door to the business office unlocked, but forgot to disable the security camera. That night, the accomplice entered the unlocked business office, but was surprised to see the business manager inside. The accomplice then struck the business manager with a paperweight and emptied the safe. The accomplice was arrested shortly thereafter and immediately confessed, implicating the security guard. The security guard was arrested and charged with burglary. A trial in federal court, the prosecution offered an unaltered digital copy of the videotape taken by the security camera on the night of the burglary. So it's a copy. So this is probably getting at the best evidence rule. What is, is it, does this qualify as the original? The security guard objected, claiming only that the original videotape had to be produced. So they're not disputing the authenticity of it. So A says the court should overrule it because digital copies of an original are admissible per se. This overstates the law. It forgets about the exception. The court should overrule it because the security guard did not question the authenticity of the original videotape. That's true. So that gets at the exception. So B is the right answer. And here, and this is true a lot. Hey, Maria, and Martha. This happens a lot where B is a good answer because it gets at the exception. So sometimes you'll see a more general rule. So it should say, let me think. Like the court should overrule it because digital copies of the original are admissible. So like, let's just say we struck where it says per se, right? So something like that, because it says digital copies of an original are admissible. It would still be incorrect that way, but we want the one that also encapsulates the exception to the rule, which is, all right, it's a copy of the original and that is okay. And there was no challenge to it. So that includes the exception. C, the court should sustain the objection because a digital copy is not the original. That's not true. A digital copy can qualify as an original. And D, the court should sustain the objection because the original videotape is the best evidence. And we don't need the best evidence. It just needs to satisfy the best evidence rule. It hasn't been questioned its authenticity and the copy can count as an original. So I would say like this mischaracterizes, again, the facts and doesn't need to be the best evidence. You guys hanging in there? Hope you're all hanging in there. All right. How should the court rule on the motion for remand? All right, we're getting into some Civ Pro finally. A traffic accident occurred in state Y involving a driver from state X and a citizen of a foreign country who had been admitted to permanent residence in the US and was domiciled in state Y. So we have a driver from X and a citizen, and a foreign citizen, but who's domiciled in Y. So there is diversity. The state X driver brought a negligence action against the foreign citizen. So I'm going to do the driver who's from X. It's a foreign citizen who's from Y, alleging 80,000 in damages, so 80K. So there's diversity, amount, and controversy, and they brought it in state Y, right? So big thing to notice here is it's brought in state Y, and they're from state Y, so they can't remove. So removal is not an option here. The state X driver moved to, the foreign citizen filed a timely notice of removal in the federal court in state Y. The state X driver moved to remand the action back to state Y, back to state court in state Y state court. which the court should remand it because it was not proper to remove the case because of the defendant citizen rule. All right, so the court should deny the motion because complete diversity exists. Doesn't matter. So it's the incorrect result. And it's insufficient just for there to be complete diversity. So yes, it's true. I'm not going to say true, but insufficient. The court should deny the motion because the driver alleges $80,000 in damages. Again, that's true, but it's insufficient. You have to have, so because in order for removal, there has to be a basis for removal, right? So diversity jurisdiction or federal question jurisdiction. Also, there's supplemental, leaving that aside for a minute. And then you have to satisfy all of the like mechanics of removal. So there's all those little rules around it too. So again, this is true, but insufficient on its own. The court should grant the motion, which is what it should do, because the action was filed in state court and statewide. That is the valid reason, because we're looking for that, the fact that the defendant is a citizen of statewide. This is like the forum citizen bar. And then the court should grant the motion because the federal court lacks SMJ in actions involving a citizen of a foreign country. This just misstates the law. So C is our correct answer here. A lot of people picked A. And that's you're just focused on SMJ. So you're spotting this as an SMJ issue. It's SMJ removal, fine. But you're not, you're forgetting that extra little rule and probably not mapping it out. And just as a heads up, in 2 weeks on December 4th, I'm doing, for everybody here that's taking California, I am doing a workshop about taking the exam online and what that's going to look like. How do you properly take notes online? How do you do the PT without hard copies, et cetera? So make sure you're registered for that if you're taking California. You can sign up for it on my free study resources page on my website. All right, question 16. Does a federal court have jurisdiction to hear the claim against the cashier and counterclaim against the bookkeeper? This one I thought was a little tricky. I'm curious to see all of y'all's answers, but I definitely thought this was a little bit tricky. So on a stormy day when visibility was low and the rain was falling hard, an author from state A was stopped at a red light in state B. Behind the author, a bookkeeper from state B rear-ended the author's car. Behind the bookkeeper, a cashier from state B then rear-ended the bookkeeper's car. All of the events happen in quick succession, meaning they all arise out of a common nucleus of operative fact. The author sued the bookkeeper in the federal district court in state B, seeking damages of $180,000. The bookkeeper then impleaded the cashier, seeking damages of $150,000. So here we have, the author sued the bookkeeper. They don't tell us where they're from, or do they? Yeah, actually they do. All right, they have the author. Where's the author from? State A. And the bookkeeper is from state B. That's handy. And then I think the cashier is from state C. No, the cashier is from state B. So you notice here between the two that there is complete diversity between A and B, but there's not between B and C. So the question is there supplemental jurisdiction here? Let's see, what did most people, okay, good. So yeah, the cashier counterclaimed against the bookkeeper seeking damages of $30,000. So does a federal court have jurisdiction to hear the claim against the cashier and the counterclaim against the bookkeeper? So we're just concerned about this claim. So do we have an independent basis for SMJ? Yes, we do. We have this claim here, and it's for $180,000. So we have SMJ for A and B. So then is there supplemental jurisdiction? Well, does it arise out of a common nucleus of operative fact? Yes, it all arises out of the same accident, so they can. So there is jurisdiction to hear the claim against the cashier, but not the counterclaim against the bookkeeper. That's incorrect because there is supplemental jurisdiction, because it all arises out of the same common nucleus of operative fact, the CNOF. And then B is the same thing. There is jurisdiction to hear the counterclaim against the bookkeeper, but not the claim against the cashier. Again, same as above. So I'm just going to write SAA, which means same as above. So incorrect because supplemental jurisdiction because there's a common nucleus of operative fact. C, there is jurisdiction to hear both the claim against cashier and the counterclaim. That's our correct answer. And then D is incorrect, same as above. You see how, and this is, somebody asked me about BarMax's answer explanations, and sometimes UWorld does this too, which I don't love. Is there just like same as above, same as above? I don't always like that. This is the first time in these 16 questions where I'm like, it is truly the same answer explanation. Usually like there is a very unique reason that each answer option is incorrect. And that's what you want to look for every single question, every single time. So just wanted to point that out. All right. An employee sued a corporation in federal court claiming he was denied compensation. Oh, sorry. How should the court rule on the employee's motion? Generally with these questions, And like, I'm not going into all of my tips and all the subjects. Like I do that in my MBE minutia class, where we do that. I co-taught it last time. And in my book, I give tons and tons and tons of that. This one, I just wanted to go through the questions, demonstrate the differences that I see between these and the questions you may be used to, the MBE questions. And then also just talk about, like, I wanted to demonstrate the way you should be going about looking at the answer options. So, and the name of the book is The Best MBE Book. I can put a link to it at the end of it, but it's on my website. It's called The Best MBE Book. And I think that is probably one of the best resources. Somebody that I was talking to today that's here told me, I mean, their MBE score went up 200 points after using my book and doing a lot of work. It wasn't just the book. Yeah. All right. So how should the court rule on the employee's motion? Whenever I see this, I want to see, they usually tell you right above what the issue is or what the motion is. So an employee sued a corporation in federal court claiming he was denied compensation under his employment contract. During discovery, the employee gave notice that he intended to depose the corporation and thereafter met and conferred with the corporation concerning matters about which he wished to examine the corporation, i.e. financial records relating to his compensation. Thereafter, the corporation designated one of its managers to appear and give testimony at the deposition, and the employee served her with a subpoena. So all of this is going well. They're doing what they're supposed to do. During the deposition, the manager testified that she was unfamiliar with the corporation's financial records relating to the employee's compensation, and that the corporation failed to disclose any such records to the manager prior to the deposition. So the corporation's totally in the wrong here. The employee then made a motion for sanctions. Sanctions would be valid in this case. How should the court rule on the motion? A, deny the motion because the employee had an obligation to identify an appropriate witness to appear at the deposition. That's incorrect. So this misstates the law. It's not on the employee to identify. It's on the corporation to identify. B, deny the motion because the employee should first make a motion to compel disclosure. You don't have to do that. So again, this misstates the law because it's not required. Actually, I'm just going to say it overstates the law. MTC is motion to compel. That my little O with the line through it is not. Often you do have to meet and compel. Often you do have to meet and confer when dealing with a situation like this, but or dealing with discovery. You do often have to do that when you're answering questions and they're refusing to answer. But in a situation like this, the corporation has to actually give the person that can answer the questions, and they didn't do that. So it's this particular sort of area where they can get sanctions. You don't have to meet and confer. All right. C, grant the motion because the corporation had an affirmative obligation to designate an appropriate employee. Yeah, that is what they have to do. And the court can grant sanctions without the motion to compel. And D, grant the motion because the employee will incur additional expense in scheduling another deposition. This is true, but it's not a basis for sanctions. The sanctions will probably cover those expenses, but that's not the basis for it. So C is our correct answer here. Somebody asked if I recommend the MBE book be used in addition to Adaptibar. Yeah, I absolutely. It has 410 questions in it. You should be doing a total of about between 2,000 and 2,500 questions to prepare. And you should be doing those questions like I'm doing them, where we're looking at every single answer option. Vasu, honestly, somebody asked, yeah, what would be better if you can only afford one? They're so different. I think, the MBE book has all the law. The MBE course is really walking you through questions, and so the course and the book are different. And the book doesn't include the course, they're separate. Or the course doesn't include the book, rather. All right, let's look at question 18. So who, if anyone, is liable for the unpaid rent? All right, so we're probably dealing with landlord-tenant. So finally getting to some property. So a law student signed a written 3-year lease with a landlord to rent a 1-bedroom apartment. After the first year, the law student decided to take some time off from law school and travel the world. Good for them. The law student subleased the apartment to a nurse for 1 year. The landlord was aware of the sublease and did not object. The nurse paid the rent for 6 months. After 6 months, she was transferred out of state and left the apartment without paying any further rent. So nurse is not going to be liable to the landlord, but the nurse is going to be liable to the law student. When the law student returned to the apartment after being away for 1 year, the landlord demanded that the law student pay the last 6 months of unpaid rent. The law student refused and told the landlord to sue the nurse for the unpaid rent. Law student's wrong here. Maybe shouldn't have gone on that year-long vacation. So who, if anyone, is liable? Neither. That's incorrect because the law student has a lease. So there's privity of contract. The law student is liable to the landlord. The nurse is liable to the law student. This is our correct answer. The law student and the nurse are jointly liable. This is incorrect because the nurse is not liable to the landlord. There's no privity. And D, the nurse alone, again, this is same as here. Same as here. Yeah, I generally thought these questions were easier than, well, then there's this one, which I think is a little bit trickier, but I generally thought these questions on the whole, but it also just may be that like, I know all of the questions, but some of the NCBE questions, I'm like, ooh, when I see them still. All right, will the neighbors prevail in their action to stop the construction of the garage? A buyer wanted to buy an affordable lot on which to place a manufactured home. The buyer found a neighborhood of more than 120 small lots, so there's a lot of lots here, each of which had a manufactured home on it. The buyer noticed that none of the lots had a garage, so this looks like a common plan or scheme, or like a common plan. So an implied reciprocal servitude, is that right? But that each lot had a driveway and a side yard. None of the lots belonged to the original owner, the original subdivider of the land. However, a recorded plat showed that the lots were meant for one-story manufactured homes without garages, so there is record notice. The buyer did not review the recorded plat, doesn't matter. Neither did the buyer review any of the recorded deeds to the lots, more than half of which contained express restrictions prohibiting garages. Doesn't even matter though, because it's apparent from looking at it, there's a common plan. All right. This one, there's some trickiness with the language and the answers. So I actually like this question a lot. I thought this was kind of fun. The buyer purchased a lot, obtained a deed containing no restrictions. The buyer began construction on the lot of a manufactured home and a garage, which would have taken up the entire lot, leaving no yard space. The neighbors saw the construction and brought an action to obtain an injunction to stop the construction of the garage. Will the neighbors prevail in their action to stop the construction? A, no, because none of the lots belong to the original subdivider. This is incorrect because it's unnecessary. So this just, overstates the law for the original to be involved because there's a common plan. B, no, because the buyer's deed contained no restriction prohibiting a garage. It doesn't need to have one because there's a common plan. Okay, the difference between C and D. So the difference between C and D here is just a word. Yes, because a covenant running with the land covers all the lots, or yes, because an equitable servitude covers all the lots. What's the remedy they're seeking here? Yeah, a covenant is monetary damages, and an equitable servitude is an injunction. They want to stop the construction of the garage. Yeah, so D is our correct answer. So I thought this was really tricky. And whenever I see that there's two answers that are really similar in the language, then I'm like, well, what's the difference between them? I'm like, oh, it's, a covenant running with the land or equitable servitude. Covenant also requires privity, and there's not privity here. So this is one of those ones where you really have to, identify that there's a common plan here and identify that this is an equitable servitude. Yeah, it's really only tricky if you don't know the difference. But I think that like it's tricky just, noticing that it's just that one word, the covenant running with the land versus equitable servitude. All right. Is it likely that the buyer will prevail? We're almost done here, everybody. Good job for hanging in there. A buyer was looking to buy an already existing and operating chemical plant for a reasonable price. After 18 months of searching among comparable chemical plants, the buyer finally found one at a reasonable price in an economically depressed area. The buyer entered into a contract with the seller, agreeing on price, terms, and a closing date. The seller soon discovered that the buyer had religious beliefs to which the seller was opposed. The seller contacted the buyer, stated that he would never sell to him, and repudiated the contract. But what do we know about land? Land is unique, right? The buyer nevertheless appeared on the closing date, ready, willing, and able to close at the agreed upon price. The seller did not appear. The buyer has initiated a suit for specific performance. Is it likely? Yeah, because land is unique. So A, no, because comparable chemical plants were available. It's irrelevant because land is unique. No, because rescission is the only remedy available for breach of a real estate contract. This misstates the law. You can also get specific performance. There's other stuff too. Also, this is an absolute only, right? We don't like that word. Plus others. You might want to like list out what are all of the options. C, yes, because each piece of real estate is unique. That's correct. And D, yes, because the seller had an improper reason for repudiating. It's irrelevant, the reason. Irrelevant what the reason is. You can't do it. And it looks like most of you got that one. So a bookstore owner believed that printed books would, can the mortgage obtain a deficiency judgment? So I'm dealing with foreclosures, mortgages, stuff here. Can the mortgagee obtain a deficiency judgment against the bookstore owner for the unpaid $200,000? A bookstore owner believed that printed books would again become popular, even as digital books were becoming more popular. Consequently, the bookstore owner decided to enlarge his store, which sat on a parcel that he owned in fee simple. He took out a mortgage of $300,000 in order to enlarge the store. After the construction was complete, the bookstore owner filled the new space with more printed books. Thanks, Berto. However, customers became fewer and fewer, and the bookstore owner lost money each month. Shocker. He soon defaulted on his mortgage payments, still owing $300,000, and the mortgagee began foreclosure proceedings, which they're allowed to do. The bookstore owner offered the mortgagee a deed in lieu of foreclosure. If they had accepted the deed in lieu of foreclosure, then we'd be done here, but they don't. But the mortgagee refused it and foreclosed. The bookstore and its parcel were auctioned off at the foreclosure sale, bringing in only $100,000. They should say here that it's by somebody unrelated to the mortgagee. So there's some more facts should be here. But other than that, this is okay. So can the mortgagee obtain a deficiency judgment for the unpaid $200,000? And yeah, they can. You're allowed to do that. So no, because the bookstore and its parcel were sold at the foreclosure sale, which resulted in extinguishment of the mortgage. This misstates. This is incorrect because it doesn't extinguish. It just eliminates that 100,000. No, because the bookstore owner made an offer of a deed in lieu of foreclosure, but this is irrelevant because it was rejected. Only an offer. Only an offer is insufficient. Yes, because party of the original debt remains unpaid. That's the correct answer. And D, yes, because the bookstore owner should have known that enlarging his store would not succeed financially. And yeah, this is just not a valid basis to get a deficiency judgment, for enforcing the deficiency, I should say. So C is our correct answer there. Most of you got that. 22. So how should the court rule on the diner's motion for summary judgment? So a customer went to a diner for lunch and approached a counter with a row of stools. Each stool had a metal base bolted to the floor and a wooden seat attached to the top of the base with screws. When the customer sat on a stool, the seat came off the base, causing the customer to fall, hit the floor, and suffer a back injury. An examination revealed that each of the screws that held the seat to the base was broken. The customer brought a negligence action against the diner. In a deposition, the customer acknowledged that he did not know when, why, or how the screws broke. But generally, an incident like this doesn't occur in the absence of negligence. So you can do res ipsa here. Often when you see a motion for summary judgment or a directed verdict or JMOL in a torts question, you want to think about res ipsa and negligence per se. In her deposition, the diner's manager testified that she regularly inspected the stools and had found no problems with any of them. After discovery, the diner filed a motion for summary judgment, arguing that the customer had not presented any direct evidence, but they have presented indirect, showing that the diner had been negligent. How should the court rule on the diner's motion for summary judgment? So the court should deny the motion because a genuine issue of material facts exists about whether the diner was negligent per se. We're not talking about negligent per se here. I'm going to just say NPS is not present here. We were not given a statute. B, the court should deny the motion because a jury could infer, res ipsa, that negligence occurred even if the customer offers no direct evidence. That's our correct answer. C, the court should grant the motion because the customer had not presented any direct evidence showing that the diner had been negligent. Don't have to present direct evidence. And D, the court should grant the motion because the customer voluntarily chose to assume the risk. They didn't voluntarily assume, they assumed the risk of sitting on a stool, but they assumed the stool is going to be supportive, right? They didn't assume the specific risk of the stool being broken. So I would say this mischaracterizes the facts because no specific knowledge of the risk. 23. What's the strongest argument the mall can make to avoid liability for false imprisonment? So a shopper drove to a shopping mall and went inside to shop at several stores. When the shopper returned to her car, she found that a parking boot, i.e. a device to immobilize the car, had been attached to one of her car's wheels. The shopper went to the mall's security director, who told her that a mall security guard had attached the boot because the shopper's license plate was in the mall's database of vehicles that had repeatedly violated parking rules and restrictions at the mall in the past. Sorry, the shopper said that this was the first time she had ever visited the mall. The security director checked the mall's database and determined that the security guard had misread the shopper's license plate number. The security director apologized and had the boot promptly removed. The shopper was delayed at the mall for 40 minutes. The shoppers filed an action for false imprisonment against the mall. I think this is a pretty good question. What's the strongest argument the mall can make to avoid liability for false imprisonment? So what did you guys pick here? A lot of D. Yeah, okay, mostly D. Some A's, some B's. All right, so A, the security guard's misreading was not intentional. It doesn't matter. They intentionally placed the boot on the car. B, the security guard's misreading of the license plate number did not cause appreciable harm. This overstates the law. You don't have to cause actual harm. Appreciable harm here means actual harm. C, the shopper was delayed at the mall for only 40 minutes. The length of time is irrelevant. And D, the shopper was not confined at the mall. This is the correct answer. They could have left. They didn't have to stay and wait for their car. They could have called an Uber, called a taxi. They could have walked, anything. They weren't actually confined. So this one I think is tricky. But yeah, I mean, this is one of the better questions. All right, number 24, we're almost done here. Is a neighbor or the homeowner likely to prevail? So a homeowner had a pet squirrel. This is not common. I also saw here it says is neighbor or homeowner likely to prevail. I see here that they're telling me it's strict liability. Yeah, so this is getting at abnormally dangerous animals. This is a wild animal or domesticated. Yeah, but it's really a wild animal. So a homeowner had a pet squirrel. The squirrel never left the homeowner's house, so no one in the neighborhood knew that the homeowner had a squirrel. The squirrel was generally playful and had never injured anyone, but it occasionally displayed aggressive behavior when encountering an unfamiliar person for the first time. A neighbor was expecting an important letter in the mail, and when it was late, she thought the letter might have been inadvertently delivered to the homeowner. The homeowner's front door was slightly ajar, so when the neighbor knocked on the door, it swung open. The neighbor called out to see if anyone was home, but got no response. The neighbor saw some mail piled on a table in a hall, so she decided to step inside, trespassing, to see if her letter was there. As she looked through the mail, the squirrel entered the hall and bit the neighbor's leg. The neighbor sued the homeowner in strict liability. So is the neighbor or the homeowner likely to prevail? The homeowner, because the squirrel had no prior history of biting people. It doesn't have to have a history. It displayed aggressive behavior. So this is incorrect. You don't have to have a history of biting. So aggressive behavior would be sufficient. B, the homeowner, because the neighbor did not have permission to enter the house. This is our correct answer. So it can be a defense to the abnormally dangerous animal when the person is there illegally. C, the neighbor, because a person who keeps a wild animal is strictly liable for any harm caused by the animal. This has the word any in it, and it's overbroad. So that is overbroad. They're not liable for any harm. They're liable for harm caused by the dangerous aspect of the animal, this is the dangerous aspect, but C still misstates the law. So I'm going to say this misstates the law. And D, the neighbor, because she had no reason to know that the homeowner had a pet squirrel. She doesn't have to know in order for there to be liability. But here, she doesn't have protection because she didn't have permission to enter the house. All right, last question here. All right. So will the shopper or the store prevail? A shopper in a drugstore wanted to purchase shampoo. The shopper saw that the store had several bottles of the brand of shampoo he preferred, but they were on the top shelf of a display case too high for the shopper to reach. He did not see any employee in the area who could assist him. That being so, he stepped on the lowest shelf of the display case in order to climb to reach a bottle of the shampoo on the top shelf. When he stepped on the shelf, it gave way under his weight and he fell and injured his hip. The shopper has brought an action against the store for strict product liability, claiming that the display case was defective in design and or in manufacture. It may be defective, but you have to be a commercial supplier of the product. They're not a commercial supplier. So will the shopper or the store prevail? A, the store will prevail because the shopper was negligent for stepping on the display case's lowest shelf in order to climb to reach a bottle of shampoo. It's true, the shopper was probably negligent, but this isn't a basis to overcome the strict products liability. So, even if true, I'm going to say it's just irrelevant to strict liability. B, the store will prevail because the store does not sell display cases, i.e. they're not a commercial supplier. And they're not. They don't sell display cases. If it was the shampoo, yeah, it was defective, but it's not. It's a display case. C, the shop will prevail because the store can be subject to strict product liability for a defective product, even if it did not design or manufacture it. That is true. A store can be subject, but the shopper won't prevail here because they're not a commercial supplier. So this is a true statement, but not a commercial supplier. And D, the shopper will prevail because the store should have had an employee available to assist the shopper. This isn't a requirement for strict products liability. It's irrelevant to the products liability claim. That's it, everybody. Are you guys tired after that? I'm a little bit tired. All right. So I hope that was helpful. The level of depth when you are answering, questions, you should be able to quickly write, why is this wrong? And if you can't do that, If you can't do that, like I just did, then you need to dig deeper and you need to really understand, why an answer is incorrect. Okay. All right. Now, everybody, hang on for just a second. And I'm glad that you guys found that helpful. So I'm going to answer some questions and then I'm going to end the recording. And for those of you that are here, I have a little discount code for live attendees. So questions in the Q&A. If you have a question that you want answered that you put in the chat, put it in the Q&A because I get tons of messages during this. All right, Jennifer, it's not too late. Somebody asked what I would recommend to review the MBE topics. It doesn't really matter. I just think you should always start with civil procedure. Oh, somebody asked, can I go over the main differences between UWorld and Adaptibar? They're really similar. UWorld has more questions in it, but they're questions that UWorld wrote, not real questions. UWorld, the answer explanations are different. They have a lot more imagery, which a lot of people like, and they have some really helpful tables. UWorld's questions that are not real test points of law that I haven't seen in some of the real questions. So I do think that that's helpful. Adaptibar, I think, has much more thorough answer explanations. Still doesn't always tell you why you got it wrong, and that's what you have to figure out. Oftentimes when people are getting close, they're not really understanding like really why each answer option is wrong. So yeah, so you really have to be very thorough with either one. And you have to really ask yourself why you missed the problem. Was it like a particular fact that led you astray? So just a whole bunch of stuff. There's a whole ton of reasons. And I do MBE tutoring. I do it a ton. So if you guys are struggle with the MBE, that's something we can help with. Minor can disaffirm after reaching the age of majority. Somebody just asked a substantive question. Somebody asked which I would recommend for someone who can only afford either MBE minutia or the book. They're just different. The book, the MBE book has all the black letter law, strategies and tactics, like tips, etc. And it has questions, 410 questions targeting the law that you just reviewed. So I really try to break up the MBE and make it manageable. The MBE class is really like walking you through. So if you need that demonstration, the course will help you do that. So I think I always think the book is a really good place to start because it includes the 410 questions and all the black letter law. So I guess I would say that, even though it's less expensive, I would say that if you can only afford one. I think both is the best thing to do. But so somebody asked, since the exam doesn't provide physical copies, you can't quickly annotate on paper. I know that. I do really think like you should practice. And when you're learning right now, early on, you can still practice on paper. Like my MBE book is really good for that. That being said, the questions between Kaplan and NCB, they're really not going to be any different. So Kaplan is not allowed to look at MBE questions when they're drafting theirs. They have to independently draft them, but they're following all of the same rules for drafting that are used to draft the MBE questions. And yeah, so there really shouldn't be differences. I'm going to talk through strategies for taking notes when you're doing the multiple choice, how to take the PT without hard copies in the webinar on December 4th. So make sure you're signed up for that. Okay. Let me just get through these questions. A good way to take notes, I'm going to teach you guys how to effectively take notes using that like digital whiteboard that they provide. So you'll take notes in there. Also in my book, there's really good tips on taking notes. And in MBE Minutia, I also demonstrate taking notes. My discount code for Adaptibar is BarMD 10. I'll type it in the chat. So that's my discount code for Adaptibar. My MBE book is called The Best MBE Book. I'll put a link to it in the chat. There's the link. I don't know if Kaplan's going to be easier. I don't think it should be easier, but these questions to me certainly seemed a little bit easier. How do you dig deeper when reviewing the black letter law? You do what I just did. You say if there is a single answer explanation that you cannot thoroughly explain, if there is a single answer option that you cannot thoroughly write an answer explanation for, you've got to dig deeper into that. So you need to look at every single word. What is wrong with it? It's not. I know somebody asked, has anyone bought a whiteboard? It's a digital whiteboard. You don't get to have an actual whiteboard. It's just like a little thing in the screen. So you're not going to have a whiteboard. Any questions how to craft wrong MBE notes to better understand the questions? It's just that's such a complex thing, and I don't have a simple answer to that. I don't know. I'd have to think about that for a little bit. When you start increasing the number of MBE questions you do in a seating, if you're going for endurance, the reason to do sets of 50 or 100 is to just really work on endurance. And when you're doing that, you got to do the questions straight through and then review afterwards. The questions on the exam will be mixed. They're not going to be organized by subject like this. Yes, it's possible to get a passing score even if you failed 6 times. Your score is a 1260, you can get it on the next go. You need to be really strategic, and you should make sure that you've had a chat with us. Most of our workshop courses will start on December 1st is like the start date. I put a study schedule that has its December 1st start date. And you just select the courses. I can help you with it. Yeah, and I do an exam results review. If you have not scheduled a score review session, I'm going to copy my link and you can schedule a session to chat with us. I just put it in the chat. Jennifer, I'm happy to meet with you too, just because I know you've had a few questions. I'm happy to meet and clarify. It's probably easier to talk through. I'm getting this question a lot. Will it be helpful to practice old Kaplan MBE questions? No, because those are derived from the NCBE questions, which they can't do. These are all brand new questions. So no, and like they brought in a bunch of people to draft them that I don't think had been previously used before. I recommend somebody asked, do I recommend a remote at home or the test center? I would do it at home. You can control your environment. Anonymous person that asked what your routine should look like. It depends on the person. You should make a score review. Sarah, I think, see, people were telling me different things about this. Sarah, let me double check on that. I appreciate it. I swore that people were like, no, it's digital. So let me just double check that. So I appreciate that. Thank you. I do think if you have the Kaplan books, I think that that's fine. I think that that's a good resource, but like, don't, just do those questions because they're Kaplan. Like Kaplan had to leave the market in California. Practice Adaptibar or UWorld questions. And I will give the discount code once I stop recording. And I do have a book on tackling the essay portion. It's called the Best Essays book, and it's templates for basically any issue on the bar exam. Yeah, and yeah, for remote, you have to have, yes. Okay, so Adaptibar has the NCBE, MBE questions. So does UWorld. So does every bar prep company. There aren't currently other questions other than these 25 that exist. So the best resource is MBE questions because all the questions that are being drafted follow the exact same rules that were used to draft the MBE questions. So yes, use UWorld, Adaptibar, all of the resources that you would previously have used. Yeah, testing centers, there's too many. Like to me, there's too much that's unpredictable. And NCBE, they will not use the NCBE questions. My essay book doesn't have essays in it. No, it's a book of literally templates for how to write any essays. These questions are very close to the actual MBE questions. I think they're a little easier. Somebody's asking me about SARX. SARX is and I can show you guys, it's my essay portal. We have like 30 plus years of past essays in it for California. Every essay is organized by topic. So one thing that's really important when you're practicing essays, and we have it for UBE and California, and SARX is, let me just show you guys. Every single question has an issue checklist telling you the minimum issues you needed to address to get a passing score. So that's what is unique about SARX. I don't think using old Kaplan question is less helpful. I just think it's the same thing. It's not going to be more helpful than anything else. So I'll show you guys SARX, and then I think that covers pretty much all the questions I got asked. And Lewis, you need to use another resource other than my MBE book. You need to do more questions than the 410 that are in the book. So like here's the California SARX, for example. So there's all the subjects are in here. So civil procedure. And then you can see here, these are all the topics that get tested within civil procedure. So like if you want to do a PJS and JSA, here's all the PJS and JSA essays. So you can click on the question. The question is here. You can type your answer here so you can practice kind of answering this way. We have the 2 selected answers, and then we have an issue checklist that tells you what issues you needed to address at a minimum. So we have this for all of the essay questions. We have to update it with some of the more recent ones, but it's really thorough. The selected answers are from the CalBar, yes. Using Kaplan supplemental materials are totally fine, but I don't think it's gonna like give you a leg up for any reason. My current bar prep is focused, it's for the UBE, it's focused on the UBE. For California, it's, I have updated it a little bit, and I'm offering some stuff, like this where I'm talking about Kaplan. But everything, like the way that you prepare has not changed. You do not need the MBE book to take the MBE course. No, I don't have a scholarship. Somebody asked, I'm sorry. I don't know about the remote option for handwriters. We're gonna have to sort of wait and see how that's gonna work. I'm sure they'll have a test center, but I'm not sure what that will look like. At what point should you start practicing endurance for the MDEs? Like in January, at least mid-January. And yes, the allocation of subtopics should be the same. Hopefully, I was able to get to your question. If not, oh, it's measure test center for writers. Thanks, Kim. Somebody asked what our core package includes, what it doesn't include. So I'll answer this and then I'm gonna stop and I'll stay on and answer some more questions. But the core package includes we have core and we have core MBE. So core includes our essay and PT package, outlines, a study schedule, essays, PTs, all with model answers, like everything you need to pass the written portion. We also have a multiple choice portion, which includes the MBE minutia class, my MBE book, and a software platform that has all of the questions and everything in there as well. So, and then we have Core Plus. So you can then upgrade Core to Core Plus, which includes 3 tutoring sessions. 3 tutoring sessions. It includes our 7 live bar exam checkups, which is basically a proctored mini mock exam that I encourage everybody to come to. We provide all the materials. It's a 3-hour session. You either write essays that we give you or 2 PTs. It's either 3 essays for California, 6 for UBE. Jennifer, I don't, but I don't know, maybe we can figure something out. I've never been asked that. So it includes 3 tutoring sessions, those 7 bar essay checkups, and it includes my books. So it includes my best essay book and best PT book. I'm going to stop recording. Thank you, everybody, for joining me. Hang on one second.